Well, hello everyone. Welcome to today's program, What Every Construction Lawyer Should Know About SB 440 and Mediation Confidentiality. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speakers, Ted Levin and John Hanover. John is a mediator and arbitrator at ADR Services. He is a former construction litigator, and for nearly 4 decades, his practice focused exclusively on construction law, representing owners, contractors, design professionals, and insurers in complex disputes involving contract claims, delays, defective work, payment remedies, and unforeseen site conditions. He has handled hundreds of jury and non-jury trials, arbitrations, and mediations across private and public works. He previously led the Construction and Government Contracts Practice Group at Alston and Bird and served as the managing partner of Pekar and Abramson's West Coast offices. He is ranked Band 1 in construction by Chambers USA, listed in the Best Lawyers in America for Construction Law and Construction Litigation, and is a fellow of the Construction Lawyers Society of America. He serves on the American Bar Association's Forum on Construction Law and previously chaired the Construction Law subsection of the Los Angeles County Bar Association's Property section. Ted is a construction attorney, mediator, and arbitrator at ADR Services. He holds the unique dual credentials as a licensed California civil engineer and attorney, with more than 38 years of experience in construction law, professional liability, and dispute resolution. His practice has covered construction defects and delay claims, contract analysis, risk management, and professional negligence involving design professionals, contractors, owners, and insurers across projects ranging from residential work to public infrastructure valued in the hundreds of millions. He has served as a partner at Clark Hill and Morris Pollock and Purdy, and has lectured and published extensively on legal developments affecting construction and design industries. He's recognized in the Best Lawyers of America for construction law and as a Southern California super lawyer. We're so excited to hear what they have to share with us today. So without further delay, I'm turning it over to them.
All right, great. Well, thank you for the introduction, and thank you to everyone for being with us today, either live now, virtually, obviously, but listening to the recording at some point. Ted and I have had a great time actually preparing for this, analyzing the statute, looking at some details, comparing it to the public code, public contract code, section 9204, and really trying to figure out how this will both impact the industry and how it will impact contract drafting and transactions in the future. Next slide, please. We have a lot to talk about, so we're gonna move through the slides rather quickly. We'd like to reserve some time at the end for questions, and if you have questions during the program, please put those in the Q&A that should be in the ribbon below the presentation, so that if we have time during the presentation, we'll take those up, or we'll take them up at the end of the presentation. The statutory scheme is critical because it relates to private works. The prior public contract code section 9204 related only to public works, and so it's really addressing dispute resolution in a larger part of the California market. And just to give you some idea of the numbers we're talking about, the construction spending in California is estimated to be somewhere between 380 billion to 500 billion, which would make it almost 10% of the California GDP, which is roughly $4 trillion. And so the legislature turned its attention to this for a very, appropriate reason, is that if they can assist parties in kind of cash flow and moving projects along and not accumulating disputes until the very end of the project, then that is a valid purpose for the statute, to avoid that cost and delay and other litigation that is going to arise from those disputes. So that's why we're talking about it today, and the reasons this procedural tool is so critical to the industry. Next slide, please.
Thank you, John. So, the statutes involved first arise from the Senate bill SB440, and then were codified in the Civil Code, the two statutes, but the main one is Civil Code Section 8850, which provides the substance of the statute, which is known as formally the Private Works Change Order Fair Payment Act, is the formal name of the act. And what it does is establishes a claims resolution and importantly, meet and confer and mediation process for the handling of payment claims, change orders, and even time delay, time extensions for contractors for private works of improvement. As John indicated, there's a sort of a sister predecessor public contracts code, section 9204, much of which the language, the concepts from which then resulted in or included in Civil Code Section 8850. But this statute is important and it is sort of groundbreaking because it provides this claims process for private works of improvement. I will note that anecdotally, John and I being in the industry, that we've heard that there wasn't much pushback or involvement from the owners lobby, that the contractors got this pushed through without a lot of discourse, pushed through the legislature. And again, you'll see that the statute is rather contractor friendly. So it's a bit surprising that there wasn't more pushback from the owner's side of the business. But the statute governs payment-related disputes between parties, as I say, in the construction payment chain. Civil Code Section 8851 is just the sunset provision, and the statute repeals January 1, 2030, which obviously, as with most all sunset provisions, provides a legislative trial period. But the meat and potatoes of the statute, the law and the statutory scheme is Civil Code Section 8850, which is what we'll, of course, be focusing on and discussing here today. Next slide.
In terms of the sunset, Ted, one thing we can look at is 9204 and whether that has sunset, because originally that was drafted as a trial period as well, relating to contracts beginning January 1 of 2017. That statute has been extended one time. It is scheduled to sunset as of January 1 of 2027. So we're looking for some legislative action now to extend that, but odds are the expectation is that it will be extended. And so if we're looking at that model, then I think this statutory scheme is probably here to stay for a while.
Yeah, and I would tend to agree. 4 years is usually, especially as we know how long it takes matters to get to trial and get decided, 4 years is about as short of a sunset provision as you may see, because
Right.
As we know in the legal world, things the wheels of justice sometimes churn a bit slowly, as it may be. So that's a good point. So what is the legislative purpose and policy goals of 8850? Certainly, as we'll come through and just if you read the statute and from this discussion, you'll see is to encourage early informal resolution of payment claims by contractors, to reduce friction in the payment claim, in the chain of payments between contractors and owners. Especially as we'll talk a lot about the meet and confer process that's part of the statute, and then the mandatory mediation provisions, which are very important and important to John and me as mediators, because we see every day how mediation in the construction industry and construction disputes can lead to resolution. So there's early resolution opportunities, which will reduce filings in the courts. We know our courts are overburdened, and so the goals are admirable to reduce the amount of litigated filings, as well as other filings such as mechanics liens and others, and stop notices. We'll talk about stop notices. before they reach the courthouse steps. The statute provides economic stability in the construction industry by reducing the number of, hopefully reducing the number of claims and reducing financial burdens of prolonged disputes. As we all know, the longer disputes in any business, but certainly in the construction industry, the longer the disputes fester, the more expensive they become, not only through costs, attorneys' fees, and other expenses, but also the goodwill of the parties. And when a project is being built, it can affect the actual construction process if claims fester. So this will help provide resolution opportunities, economic stability between the parties to reduce costs and improve cash flow in construction projects, which is one of the statute is one of the stated goals of the law itself. Next slide. So what is the scope of 8850? So 8850 covers, certainly owners are a covered party. They're involved in the process. They're in fact the sort of the focus of it, because that's where the monies subject of the statute will come from. But the parties that are covered are contractors, direct contractors, as they're sometimes known, but generally a general contractor is the term that's typically utilized. Subcontractors, and then other claimants in the payment chain, such as subcontractors or even suppliers, could be covered by the scope of 8850 as having a right to a claim under the statute, which we'll be discussing. What is a claim? What are the type of disputes that are covered by 8850? They're rather broad, and one that's that I'll talk about in a moment, that's interesting and a little bit outside of just ordinary payment claims. But the statute covers progress payments, retention, change orders and change order disputes, although not statute, although entitled as a change order Fair Payment Act. It doesn't relate only to change orders and other compensation disputes tied to work performed. But notably, the statute includes time-related claims and can include claims by contractors for contractual time extensions, such as to avoid liquidated damages. So theoretically, a contractor could make a claim, not for a claim under the statute and go through the process, not for monies, any amounts owed, but only for a time extension to avoid liquidated damages under the contract. So that's an interesting concept under 8850. As we stated, under projects covered, the statute relates only to private works, and for contracts executed after the first of this year, January 1, 2026. It does not apply to residential projects unless the projects are mixed use or greater than 4 stories. And notably, just if you read the statute, section O of the statute, which provides this provision as to the scope of 8850 and related to residential projects, is a bit ambiguous as to whether it's an or an and John and I debated this in the preparation quite a bit, but the practical, more sensible interpretation is that it's an or, that it does not apply to residential projects unless they are mixed use or greater than 4 stories rather than and. But the statute's a little ambiguous in this respect when you read it. And again, we've stated this numerous times, does not apply to public works. There's a separate statutory scheme for public works projects. Next slide, please.
So let's talk about how it works. In other words, what the process is and what you do. And anecdotally, we've heard that the process is being used. Obviously, it's new, so there's no case law. There's very little case law about 9204, frankly, the public contract code section. But I think practically this procedure will have an impact, and largely because of this initiation of claim dispute process under private contracts. In public contracts, there are a lot of dispute resolution procedures that are already ironed out. There's been a long, battle in the public space about how to move those processes along. But in private contracts, not always is it specified how to do it. So here's how to do it. The first idea is the initiation of the written claim. So there has to be a written claim. The amount has to be specified, the description of the work performed, basis for entitlement, and most importantly, it has to be supported by reasonable documentation. And that is, to me, the strategic question of when are you ready as a contractor or subcontractor to submit that claim and begin this process? Because one of the issues will be the owner pushing back on this process by saying, I don't have reasonable documentation to make a determination about what's disputed or undisputed. And so you really want to have a good faith effort at reasonable documentation. Unfortunately, the statute doesn't define that in any way, just says reasonable documentation, but those who work in those claim arenas know what that looks like and how that's going to support the rest of the process. Next slide, please. So once that initial claim is served by the method required in the statute, and proper service is essential to trigger the statutory timeline, which is really what a contractor, subcontractor is trying to do, because there are consequences as you move through this statutory scheme for either participating as an owner or not participating, reaching impasse. And so you have to start the process correctly. And if you don't serve it properly, then you're not going to be able to take advantage, either as an owner or a contractor, of the claims process. So it's really got to be a written submission, and a written submission to the owner and to the direct contractor, if that's applicable. Next slide, please. Once that claim is received, the owner will have 30 days to respond in writing to the claim. And as part of that, to itemize what's disputed or undisputed. And again, that might be the most critical step in the process, because that begins an owner analysis of what's disputed versus undisputed, moves undisputed claims into a different track. And that different track is that those undisputed claims must be paid by the owner within 60 days, or they will begin to accrue a 2% monthly interest charge. And so you can hopefully take some of those claims off the table with that response, that written response, and then identification of undisputed claims that do have that penalty of not paid. Next comes, I think, Ted, the meet and confer process, and you're going to talk about that in the next slide.
Yes. So after the owner responds, and if there are still disputed claims, which there very well likely may be, then the next step under the Civil Code Section 8850 process is the meet and confer conference. And this request for a meet and confer can be done if there are disputed claims, or notably if the owner does not respond at all, then there's this right for a meet and confer with the claimant, that is the contractor, issuing a demand for an informal meet and confer conference. This conference, I will note, likely can be done these days by Zoom. I don't think it has to be done in person. There's nothing in the statute that there are some statutes times, and even as we know, even such as discovery statutes, which require in-person meetings. But I believe, and John and I think both jointly agree, that it can be done by Zoom as well as in person. Although, as we know, in person can provide benefits because you're looking into each other's eyes. So there's a meet and confer conference, which is allowed. Notably also, this meet and confer conference, there's no time limit on when after the owner responds under the process that John just discussed, where the owner provides a written response to the claim. There's no time frame in which this meet and confer conference can be requested. So the contractor can write to the owner and request this meet and confer conference, seemingly even months later after the initial claim is made and there's a response, and even after possibly even filing a lawsuit. There's nothing that prevents the filing of a lawsuit in the interim. Doesn't seem like that would be practical, but those are sort of open questions with the statute, how it will play out. So after there's the demand for this meet and confer conference within 30 days, the conference must occur. It's interesting that the statute says the owner must schedule the meet and confer conference. So the contractor requests the meet and confer, and then the owner must schedule it. And then within a short time frame, again, many short time frames within the statutory scheme, although they can be extended by agreement of the parties. But the owner's written response must come 10 days later as to any remaining disputed or undisputed claims. Hopefully, many of the disputed claims will move into the undisputed claim category. That's the hope of this statute, most definitely. And then undisputed amounts must be paid within 60 days thereafter. This meet and confer conference is sort of the core of the statute because it provides a time frame for when the 2%, we'll talk about this, the 2% interest penalty can be seen to start to run, or at least there's been discussion, detailed discussion, and a good faith participation of face-to-face meeting between the parties to discuss the issues. Next slide. And then there's even more further resolution process. And this may be if the meet and confer is the core, then the mandatory mediation is really the heart of the process. Because thereafter, if there are undisputed claims, then the parties it's mandatory that the parties shall submit the claims to non-binding mediation. And the process for determining who the mediator is it's quick. It's within 10 days after the disputed claims are identified. Then the parties must agree on a mediator. And very, very interestingly, this is very contractor friendly and driven. If there's no agreement on the mediator, then the contractor may select the mediator. Although, as we know, mediation is a self-determinative process which is not binding. But of course, who the mediator is going to be is very important. John and I talked about in preparing for this that the contractor could say, I'm never agreeing to a mediator that the owner agrees to, and I want my brother-in-law, who's an accountant in nothing against Omaha, Nebraska, an accountant in Omaha, to be the mediator. Of course, that's going to be a non-starter and be problematic. But the contractor has a lot of power under the statute to determine who the mediator may be. The parties, it would be hoped, of course, that the mediator would be a knowledgeable and skilled construction mediator who understands the issues and can help the parties reach a resolution. But there's a lot of power with the contractor in this respect. The costs of the mediator are shared equally, and then importantly, if the mediation is unsuccessful, any amounts later determined to be owed by the owner shall bear interest at a significant amount of $2% per month from the date they would have been due. So that's really as much as anything where the meat and the risks of the process come into play. Because if there are disputed claims that can't be resolved, then if it's later adjudicated that the claims are valid, then the owner can be subject to a 2% interest per month obligation, which is significant. Notable, the parties may agree in writing to waive the procedures under the statute for the meet, confer, and the mediation. Although, in my mind, certainly not advisable because obviously informal resolution is best. But the parties can agree after a claim is made to just proceed to litigation.
A couple of points on this slide, Ted. With regard to the selection of the mediator, I think the owner can insist on kind of good faith participation of the contractor in the selection of the mediator. And I think the owner's, argument there basically is if there is no good faith participation, the owner's going to take the position that the penalties and the interest that is stated in the statute do not apply or will not apply. So I think there's some incentive for the contractor to participate in good faith.
I agree.
Yeah.
It would be disingenuous for the contractor to try to game the process and think that a court is going to look favorably upon it.
Yeah, and I think also the contractor, hopefully, and the owner are going into this process with an eye towards resolving the claims, and so immediately kind of torpedoing the process with the selection of an inappropriate mediator might derail the process from the get-go. Interestingly enough, and you and I talked about this, Ted, but in 9204 in the Public Contract Code, the selection process for the mediator is completely different, meaning that the idea there is the parties would try to agree on a mediator. If they can agree on a mediator, each party would select a mediator who would then select a third mediator who would actually serve as the mediator. But the contractor would not have this unilateral right to designate the mediator. So that process was really cumbersome, maybe didn't achieve the purpose of the legislature. And so the legislature revised it essentially in this statutory scheme. One other point about the interest is, yes, that 2% a month is, really draconian. And like you and I talked about, Ted, those dollars add up quickly within the 3-year process of 3.5-year process of potential litigation and waiting for a trial date. The amount of the claim will double. And so if you're requesting $500,000 by the time you get to trial, it's going to be $900,000. So it's really a point. The other interesting thing for me is I've, as a lawyer, had many disputes about the attachment of interest and the time at which interest would start to run pre-litigation or pre-filing. This statute seems to say if the amount is liquidated at any point in the future, then that interest is going to start to run from the date that amount was due. And so I, always made the argument that the amount was capable of being determined, and for that reason, it was a liquidated claim, and interest should run from the time that it was due. If I was representing a contractor, obviously, the opposing position is it's not liquidated because there's a dispute about it and the parties can't determine it. But this statute seems to say we are determining that it will run from the date the claim was due.
And so it's been determined it's liquidated.
Correct. Right. That's the way I interpret it.
Exactly. I agree. Yeah.
So let's talk next slide about subcontractor claims, because the subs are also, participants in this statutory scheme. And the way this works is the subcontractor will, if the contractor is going to present a claim, then the subcontractor can also participate in that presentation of a claim to the owner. The subcontractor's got to provide notice of the claim to the contractor, provide again that reasonable documentation to support the claim, and then the contractor, within 30 days after receipt of that claim, has to notify the subcontractor whether or not it's going to present that claim to the owner. If it's not, it's got to give some explanation for why it's not going to do that. And as we discussed internally, there largely would be an incentive for the contractor to include that subcontractor claim, because otherwise the contractor's in the middle, meaning the subcontractor, if it later can prove up its claim, the contractor, having not passed that claim through to the owner, would be subject solely for the amounts that are adjudicated in favor of the subcontractor, as opposed to, pushing it through or passing it through. But there could be circumstances where, as the statute recognizes, the contractor would say, that's not a scope change. There was no delay. I'm not going to support that claim. And in that case, the benefit of the statute is just identifying at that point early on what that dispute is between the contractor and the subcontractor, which may lead to resolution of that claim. If the contractor does pass through the claim to the owner, then the subcontractor has an obligation to cooperate in the claim. I know in the slide it says participate, but I think I wrote that kind of loosely, but when I looked back at the statute, it actually says cooperate. So I'm not sure that guarantees the subcontractor a quote unquote seat at the table, but the subcontractor has to participate and cooperate in the informal conference, the mediation, and then obviously in the in the process. Most importantly is if that claim is submitted to the contractor, to the owner, then the subcontractor has the right to provide written approval of any settlement of the claim of the subcontractor. So it really gives the subcontractor a lot of leverage in saying, you contractor cannot settle, you can't resolve my claim without my actual approval, written approval of your doing that. And that's not the way it always works. The contractor sometimes would resolve globally those claims with the owner and then negotiate with subcontractors, even though subcontractors' claims had been submitted. And so that, I think, kind of changes the balance of power a little bit between the contractors and subcontractors. And I know, Ted, you're going to talk about lien rights, so I'm going to skip over that so that you can discuss that.
And let me say, John, I think, just quickly, as far as the seat at the table, I think this written approval by the subcontractor, this requirement, as you noted, gives the subcontractor a lot of power. And as mediators, I think we would get into a mediation and we would see the subcontractor claim, and that written approval is needed from the subcontractor, and that would almost immediately and seemingly certainly give them a seat at the table. In some respect, as mediators, you and I would go, well, what about subcontractor X? Where is she or he? What is their position on this? Let's get them involved in the discussion. So.
Yeah, no, you're right. You're right. Next slide, please. There is also a right to suspend work included in the statute. And although there is a right to suspend work, I think in Civil Code 8800 related to progress payments, this is a broader right, and arguably, I think, and Ted, I know you agree given our discussion, but that it could be instituted at the commencement of this claim process. In other words, the statute doesn't say it relates only to undisputed claims that are identified as undisputed after having participated in the initiation of the claim, the informal meet and confer, the mediation. Doesn't require that the parties go through all of those processes before getting to this right to suspend work. If there's an amount that's due, I think the contractor or subcontractor can begin this process of a right to suspend work. And this process also is very, very clearly spelled out in the statute. First, there has to be a notice of the right to suspend work, and that has to be served by certified mail, return receipt requested, that there is a payment due. So you have to start that process very explicitly by identifying what that payment is and that payment is due. And then you have to wait 30 days before providing another notice that you are going to exercise a right to stop work. And by doing that, you are setting up at least this idea that you would be able to stop work without penalty, which is really the critical part of the statute. That has to be the subject of a 10-day stop work notice following that 30-day period. And when you give that notice, that would, I think, allow a contractor, potentially subcontractor, to stop work because there is a claim due. There's no requirement that that 10-day stop work notice be given immediately after the 30-day period runs. So strategically possible, I think, for contractors or subcontractors with the initiation of the claim under the statute to also identify this right to stop work, but not serve the 10-day stop work notice until negotiations have progressed, until the informal meet and confer happens, till the mediation happens even, but going ahead and setting up this right to stop work, which may provide some leverage during the process. From the owner's perspective, I think the owner's got to be really mindful of that. I think the owner's got to be really diligent in reviewing the statutory requirements. But again, I think the legislature was really trying to put some pressure on the parties to take this resolution process seriously. Next slide, please. At the conclusion of the process, one of several things are going to happen. You're either going to have a mutually acceptable resolution, which will be binding, it will be in writing, and it will conclude the statutory process, or the parties will reach impasse, and that should be declared. And then thereafter, they can proceed to dispute resolution as identified under the contract, which may be arbitration or litigation or some hybrid, which is possible. I think that in the mediation process, one thing we didn't say, Ted, which I do want to stress, is the statute doesn't specifically say that mediation is going to be governed by Evidence Code Section 1129, the confidentiality provisions of the mediation. So I think the parties want to be sure that they are agreeing to a mediation, and the mediation under the statute will be governed by those confidentiality provisions to make sure that the process has the greatest chance of success. Next slide.
And on that mediation confidentiality topic, before I jump in on the legal effects here, that's one thing, and I'll be discussing this later, as to contract drafting strategies. That's something you may want to include in your in your contract to make it clear when outlining in the agreement 8850 and incorporating its provisions to some extent. You may want to include for the practitioners out there a provision that the mediation is covered by the confidentiality provisions under California law, because just to avoid any uncertainty. So what is the legal effect of this process? As we've seen, there's a lot to it. This statute is dense with a lot of provisions as to requirements to be met under the statute. A lot of timing provisions in it and short time provisions that practitioners should be sure to be aware of. And also, importantly, there's also waiver provisions. You can't waive in the contract the applicability of the statute, but along the way, the parties can waive portions of it, agree not to proceed, such as with and this is in the statute itself, the meet and confer and mediation provisions. So there's a lot there. And so what is the legal effect of this entire process? Well, it's non-binding, certainly, meet and confer, mediation process. None of this is, of course, is determinative. It's all based on the parties and their ability and willingness to resolve the issues. But it doesn't do away with arbitration or litigation or mechanics lien rights or stop notice rights, those other rights that are that parties may have. But it does provide, and the benefit of the statute, most certainly, as can be seen, is it's a structured opportunity to narrow issues and provides and can provide a concurrent settlement track alongside litigation, as there's nothing in the statute that prevents a lawsuit from being filed at the same time that this process, this 8850 process is proceeding. And it can also provide a mechanism to establish a record for later proceedings, or as we said here on the right, the process can also be seen as providing an opportunity to narrow issues and the scope of discovery if there are disputed claims that need to proceed. And certainly, as with any process where the parties meet, confer, or certainly through mediation, that can help reduce discovery costs, etc., by providing a platform informally to work through issues so as to streamline the litigation. But the process, as stated here, does not adjudicate rights, does not replace litigation or arbitration, and does not, and practitioners must be very, very clear on this, does not toll statutory deadlines unless the parties otherwise agree, such as mechanics lien, timing issues, stop notice timing issues, etc. Next slide. So how does the statute work with other remedies? I'll discuss these quickly to work through them. Mechanics lien deadlines, as I've stated, continue to run, and practitioners and others and contractors and subcontractors should be certain that they coordinate and are aware of the lien stop notice type deadlines, so they don't lose those rights. And so it's just a matter of being fully aware and strategic on what rights you're going to pursue and when you're going to do it, because those rights can include litigation, filing of a lawsuit or arbitration demand, proceeding with the 8850 process, because that can be done basically. There's no time frame on it during the project or the dispute process as to when the claim must be asserted. So that can be done at any time. You may want to assert the claim early if you're a contractor's counsel, assert it later after you filed a lawsuit even, although the strategic benefit of that might seem to be lost, but that's a possibility. Or determining when during the progress of the project you want to assert the rights under 8850. So there's a very strategic element here to be considered. And then obviously, again, just consider how you're going to handle your strategy under the statute with your other remedies, including liens and stop notices. Next slide. Again, this just states what I just mentioned, that that stop notices are still valid and need to be pursued, and the timing element on stop notices, whether they're stop notices to the owner or bonded stop notices to a lender, obviously beyond the scope of this discussion, how those work, but just practitioners should be aware of all the timing elements beyond involved in pursuing construction payment remedies beyond just 8850. Next slide. So as I mentioned, how does 8850 work with litigation and arbitration? The 8850 process can precede the filing of a lawsuit or arbitration demand. That would seem to be best, but it doesn't necessarily need to, at least under the statute. Certainly, what happens under 8850 can influence how the lawsuit arbitration will proceed. As far as information that's determined, it can influence the pleadings or the process, as I say, for litigation or arbitration, including discovery and information that needs to be gathered and determined during the process. So if there are still disputed claims remaining after the 8850 process is utilized, it can certainly streamline what's going to happen in the future. So that's also a benefit of the statutory scheme. And again, as we've stated, the parties may agree to waive some of the statutory procedures if they're proceeding directly to arbitration or commencement of a civil action. It would seem under the statute that the only processes that can be waived are the meet and confer and or the mediation process. And which may make sense, again, depending on the strategic standing and how the parties determine they want to move forward. But that is something to be very aware of. Next slide.
Yeah, so this, Ted, I know we've talked about strategic use and practice both for claimants and for owners. So let's talk about opportunities. Go ahead and talk about the opportunities. Maybe I'll talk about the risks as we move forward.
Sure. So so for claimants, the opportunities that can be used as a early payment pressure mechanism, certainly because of the right to the 2%. And the right to stop work, and the contractor's selection of the mediator, even those rights to be involved, those are all payment pressure points that can be utilized as an opportunity to test defenses before litigation. And then one of the most important provisions here certainly is the claimants can set up the recovery of prejudgment interest at 2% per month.
Yeah, and the other opportunity that I think it presents, and obviously Ted and I are both neutrals and are at ADR Services for the purpose of trying to resolve these claims. I think that the statute really provides structure for parties that otherwise might not get into that process on resolving claims. And like the legislature has provided, there is a benefit to resolving those claims as you move through the process. And that's a benefit for the owner, particularly because in my experience, if you don't do that as an owner, then those claims accumulate. There's more money to fight about. There are more issues to fight about. It becomes more complex. And it usually results in litigation as opposed to taking them kind of one bite at a time. And so the statute really provides an opportunity and a structure to do that, also without kind of admitting some weakness on either side, saying, well, why don't we negotiate this? Because what they're really saying is we have to comply with the statute. And so this gives us a framework to do that without essentially saying, I want to do that or this party wants to do that. The risks are, like I said, if you don't participate in this process, there could be some, ascribing that you're delaying the process. And the risk also, I think, for practitioners is you really have to be mindful of kind of the other concurrent remedies that either contractors or owners may have, because those no statutory deadlines are told because of this particular statutory scheme. So you've got to be on top of that. Let's go to the next slide. And I think in terms of, for owners, what I was describing before about getting the process going is really critical. I think that, maintaining that project momentum, because you're going to have happier contractors and subcontractors. You're going to get more responsive contractors and subcontractors, maybe even better work product if you can avoid the pay disputes during the progress of the job. And so, again, this kind of allows for that to happen in a very neutral way. I don't think the owner wants to appear non-cooperative, particularly if there is an attorney's fees provision in the contract that would give the right to a claimant, even if the claimant recovers, 20 cents on the dollar, give a contractual right to recover attorney's fees. If the contractor is deemed to be non-cooperative or the owner is non-cooperative, a judge may take that into account to the extent he or she has discretion, which they would, in awarding the amount of attorney's fees, because I think judges will get to the point of saying, well, you didn't participate in this statutory scheme, so you had an opportunity to, take the exit, you didn't. And so that party that was non-cooperative in this process, I think, could be prejudiced in the determination of fees if the court says, you bought this problem, you didn't attempt to resolve it in the way that you should have, and so I'm gonna hit you with fees either way. Next, please. So this is, just in terms of counsel, how to look at these statutory rights and the schemes. You just have to integrate it into an overall management of a claims process. This is one track, looking into it both as a precursor to mediation, a precursor to lien claims, etc., and whether you would want to initiate or bypass this process. I don't think that as an owner, you really have an ability to unilaterally bypass this process. There has to be mutual agreement. And I question whether contractors or subcontractors are going to bypass this process. I would think not, only because if they go through this process and even then reach an impasse, that 2% amount of interest accruing will be affixed to any debt that's owed, any claim that's adjudicated. So just to take advantage of that 2%, I think contractors and subcontractors will participate in the process. And so I think it will become incorporated into contracts, particularly because there are non-waivable provisions of the statute that will kind of give the rights to these kind of processes and remedies, even if the parties elect to waive it. So there's good reason to participate in the process to attempt to resolve the claims. Let's go to the next slide, please. In terms of procedural and practical pitfalls, Ted, maybe you want to address some of those.
So some of the issues to be aware of, and some of these, as we say, pitfalls or risks that are out there. Incomplete claims. The statute does, as we discussed here, refer to the contractor needing to provide sufficient, reasonable information in its claims, or the owner can deny the claim on that basis, saying that there wasn't reasonable basis support for the claim provided by the contractor. Of course, as we know, one man's reasonable is another man's, there's not enough information, and unreasonable backup provided, especially if there's like a time extension requested, and scheduling, etc. Those can get very complex, as we all know, as construction lawyers and mediators. And so you want to make sure, certainly as the contractor party, that you provide as much detail as possible and don't give short shrift to that requirement. So incomplete claims and documentation is a risk or pitfall, both on the documentation and just the statement of the claim itself. All this may undermine the claimant's position. We talked a lot about statutory deadlines. That's a risk. A failure to respond by the owner, as stated up here in the upper right-hand portion of this slide. The owner's failure to respond within statutory deadlines can create exposure to interest liability and even potentially adverse inferences if the case proceeds to litigation or arbitration. Mandatory participation. The parties and counsel should be aware of the mandatory provisions for participation, the timing on those, such as the short 10 days for selection of a mediator, and otherwise you may get, if you're an owner's counsel, you may get stuck with a contractor's mediator. So be very aware of those provisions, the timing and the mandatory participation provisions. And then stop work risks. That is and rushing the timeline for claims can create risks, and if the contractor stops work, and rushing into that could provide a possible risk to the contractor. I don't think anything here would prevent the owner from claiming, let's say, even some consequential type damages, saying you stop working improperly. You cost me money on the project. I had to go find another subcontractor or contractor. So there are risks with all of this, which requires certainly close analysis and investigation and consideration by counsel and the parties who are utilizing the provisions of 8850. So they're powerful tool, certainly, but not a panacea for everything that may occur on a construction project vis-a-vis claims and time extensions. Next slide. So importantly, especially for counsel, how to handle 8850 in drafting contracts, and what do you do, and how do you address the statute in your contracts for both owners and on the contractor side. Very interestingly, the Public Contracts Code, this section 9204, relating to public works projects, has a provision that says, I've got it right here in front of me on my screen, the text of this section or a summary of it shall be set forth in the plans or specifications for any public works project that may give rise to a claim under the section. There's nothing such as this in 8850, okay? So there's no requirement that the statute or even a summary of it be included in the project contract. However, John and I, in preparing for this, we talked a lot about this. We certainly would recommend that that 8850 be addressed in some manner in the contract, and some recognition of it. And some of the issues to be, this could be a whole other seminar, but some of the issues that could be addressed are, one, the mediator selection process, as we talked about, to avoid the brother-in-law scenario. So that's something that's clearly could and should be addressed, I believe. Also, the privilege of the mediation, that the mediation is privileged and protected, because there may be some uncertainty there. I believe that 8850 should be addressed, either a recognition of it in the contract, or even not stating the whole, as suggested under the Public Contract Code, stating the whole section of the statute. That would be obviously duplicative, but recognizing it and addressing it in your contract drafting. And
I think,
go ahead, John.
I was just going to say one point there is you can alter the timeline. So if it's a particularly complex project, you may want to alter the timelines that are identified. You can't shorten them, but you could probably lengthen them, and that might be the time to agree to them at the time of the contract execution, as opposed to during the process once a dispute has already occurred. In the interest of time, Ted, I think we should just move to 23, which identifies the sunset analysis of the provision. Again, I think it's likely to be extended, but it may sunset, in which case at the end of the term, disputes may not be subject to these provisions. I would think, given retroactivity statutes and retroactivity law, that the interest penalties would still apply after January 2030, and to the extent that the process has been completed. But I guess that's a question. Slide 24, we laid out some hypotheticals, and 25, actually, we also laid out some discussion topics or questions for everyone here to consider. I know, Ted, you and I are available to the extent people want to correspond with us after this presentation. If there are questions that you want to debate or you want to get our take on, then both of us would be available to do that. And then I do want to just, on slide 26, mention that the ADR services, again, the organization, the panel that Ted and I are on, has formed a construction powerhouse group where we have a collection of mediators and neutrals that are really experienced in construction law at ADR. And we're doing a full day complimentary construction focused webinar and presentation on July 2nd. So keep that on your calendar. I'm sure, we'll get many notices out, but hopefully people could join us for even a more in-depth review of construction related topics. So with that, I say thank you, Ted. I leave you to final comments, but I say thank you to everyone who was able to join us. Thank you to the Beverly Hills Bar Association for giving us the opportunity to present this topic.
I agree. Thanks to everyone. If there's any questions, I think maybe if there were any being submitted, I don't know, but if there were any. But otherwise, as you can see, 8850 is there's a lot there and a lot to consider, and so practitioners and construction law practitioners should be aware of the statute and its requirements and its impact.
All right. Well, thank you very much. Thanks, Ted. It was a pleasure. And thanks, everybody, for joining.
John.